So actually, it is a continuation of last session, general principles of contract. So actually, we were dealing with the general principles like what is contract. So I think most of the students might have actually have listened to that, or I think all these participants were there in the last session. I do think so. Yes. Now we'll continue with the general principles of contract. So as we all know, when a contract, there should be an offer and acceptance, then it becomes a promise. And promise, if there is a consideration to promise, then that becomes an agreement. And agreement, if it is enforceable by law, that becomes a contract. And we have also discussed that all contracts are agreement, but all agreement are not contracts. So that was we were dealing with the earlier session. Now we can just focus upon what are the essentials of a valid contract. So we have just mentioned the 10 points. Now we'll just have a detailed session regarding the validity or what makes a contract valid. And what are the essentials of a valid contract? So first of all, we have to see that there should be a proper offer and proper acceptance. Why we have to say that there's a proper offer and proper acceptance? Suppose I'm just offering my hose. I'm having a hose. And I'm just offering it. So I have to say if I'm having a black hose and a white hose, I have to say that I'm offering my white hose to Alexi. Now, if Alexi is accepted my offer, so that should be proper. So it should be definite. It should be there should not be any condition, unconditional. It should be definite. It should be genuine. It should be certain. So there should be a proper offer and proper acceptance. Whenever we are making an offer or a person is accepting that offer, that should be properly made. It should be unconditional. So that is the first part. The next point is there should be an intention to create a legal relationship. So we have just discussed in the earlier session regarding that there should be an intention to create a legal relationship. I do say that there should be a union of minds, a consensus ad idem, all we have just discussed in the earlier session. So suppose I'm just inviting Sharath for a dinner. Later on, I'm not interested to have that, and I've dropped that. Whether the Sharath can enforce that contract, whether it is a contract, whether it is having an enforceability. No, these are all mere social or domestic agreements. So that is not creating any legal relationship. So whenever there is a contract, that agreement, that should have there should be a legal relationship. That should create a legal relationship. There should be intention for the creation. A very best example, there's a case, Balfour versus Balfour. In that case, wife could not accompany her husband to the place of employment. So husband promised that I'll pay you an amount, I'll give you an amount every month. Later, what happened is this husband was not able to pay the amount. Then what happened? Mrs. Balfour filed a suit for recovery of amount. What can you say? Whether there was an intention to create legal relationship between the parties? No. That was actually a conversation or a promise between husband and wife. That was mere domestic agreement. It doesn't have an enforceability. So whenever you are entering into a contract, the terms and conditions you have to just look into. Whether the terms and conditions specify that there is an intention to create a legal relationship, then only it is a valid contract. Otherwise, it doesn't have any sort of legal liability. So Balfour versus Balfour is the best example. It doesn't actually, the husband doesn't want to create any sort of a legal relationship. It was just a domestic or social agreement between husband and wife. So that's the important case law. So, well, I told you that another important or for a contract to be valid is, of course, there should be a free consent of the parties. That is, whenever you are entering into a contract, I'm just making an offer and I'm compelling Sophia. Is it possible? Whether it is a contract? No. So there should not be any compulsion. There should not be any pressure. There should be any sort of force. So whenever I am just entering into an agreement, or whenever I'm just entering into a contract, it should be out of my free will. It should be genuine. It should not be out of any sort of compulsion or pressure. So, very simple example. So we could say that as per section, suppose I'm just asking, Alexi, just enter into a contract. I'm just offering my car. If you have not purchased it, I will just kill you. Is it a sort of compassion? Is it a sort of threatening? Is it possible? So whenever you are entering into a contract or whenever you are entering into an agreement, it is out of a free will and there should not be any sort of pressure, any sort of compulsion. So as per section 14 of Indian Contract Act, it says a consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, mistake. So section 14 that we'll be dealing in detail in the next sessions on. So whenever you are just entering, there should be a free consent when you are entering into an agreement. So a consent is said to be free when it is not caused by any sort of coercion. It should not be caused by any sort of undue influence or fraud or misrepresentation or mistake. What is the effect of all these sorts of agreement? If a person coerced you, threatened you for entering into an agreement, then the ultimate effect is voidable. What is voidable? We have discussed. It's at the option of the parties. If one accepts it, then it becomes valid. If one does not accept it, it becomes void. So that is voidable at the option of the parties. And someone is entering into a contract, it's out of undue influence. If someone is dominating the will of the other, then it is an effect of such a contract. Of course, that is also void. And out of a fraudulent, some sort of agreements are made in the fraudulent nature. The agreement is fraudulent nature. They too, the effect is voidable. And someone is misrepresenting and making you enter into an agreement. What is the effect of such an agreement? Of course, that's also voidable. So if it is coercion, undue influence, fraud, or misrepresentation, the ultimate effect of such an agreement or such a contract is voidable. That is at the option of the parties. If you are accepting all these sorts of agreements, then it is valid. And if you are not accepting all these sorts of agreements, then you can say that it is void. Then, in the case of mistake, if both the parties, so there's a mutual mistake between the parties. If there's a mistake between the offerer and suppose the promisee or the promiser or promisee, then you can say that that is a void. If it is only, if there is a mistake with regard to only one person, only one party, then it is voidable. In the case, if there's a mutual mistake between the parties, then you can say that that particular agreement is void. This is with respect to free consent. Next is, as we all know, there should be competency of the parties. What is competency or capacity of the party? The person should be attained the age of majority. The person should be of sound mind. Should not be lunatic, or the person should not be of unsoundness of mind. Should not have any unsoundness of mind. And again, you can say that he should not be disqualified from entering into contract by any law to which he is subject to. So these are the 3 points with regard to the capacity of the parties or competency of the parties. That is, should attain the age of majority, he should be of sound mind, and should not be disqualified from entering into contract by any law which he is subject to. So next point is, there should be lawful consideration. What is this consideration? I am just offering my book to Sharath. Sharath have accepted it, and he is paying the amount for the book. This is consideration. I am just giving the book to him, and he is paying for the book. So this is the consideration. That is, we could say that it's quid pro quo. That is the word. Quid pro quo means something in return. So consideration can be past, present, or future. There is a definition for that is dated under Section 2, Clause D of the Indian Contract. When, at the desire of the promisor, promisee, or any other person, has done or abstained from doing, does or abstains from doing, promises to do or abstain from doing such act, abstinence or promise is said to be consideration. It's a very long definition. Nothing to worry about it. When you're just offering, the other person is accepting, and you're giving the amount. The other person is giving you both. So this is consideration. The thing is, it need not be money alone, but it should be real. Consideration, it should have some value in the eye of law. It need not be adequate to. For example, I'm just selling my table worth 10,000 rupees, but I'm selling only for 8,000 rupees. So if there's a consideration, it need not be adequate. It need not be adequate. Okay, it should not be exact. Something in return, that's all. It need not be money, but it should be real. It should not be some imaginary items. It should be real. And it should have some value in the eye of. So if you are just offering suppose 5 lakh rupees worth property, and somebody is purchasing for 3 lakhs, that's a consideration. So that is consideration. But the thing is, whatever you are just paying or something in return, whatever there is, it should be lawful. So what makes a consideration unlawful? That is dealt under Section 23. What makes consideration unlawful? That is, if it is forbidden by something, it is forbidden by consideration. Or could say that it is having some fraudulent act, or it is causing some injury to the person or property, or if it is immoral or opposed to public policy. If these are the considerations, then of course that is not lawful. So whenever you're making an offer, other accepting, and there's a consideration, so that consideration should be lawful. It should not be unlawful. So unlawful means if it is forbidden by law, if it is fraudulent or causing injury to the person or property, or opposed to public policy, or immoral. So these are dated as Section 2. So I think you got lawful consideration. Next is lawful object. Suppose I am just giving my home for rent, but the object of that particular person's for actually taking for the rent of my house is for just gambling purpose.